Termination clauses are one of the most critical components of any contract, yet they're often overlooked until it's too late. These provisions determine how and when parties can legally exit their agreements, potentially saving businesses from costly obligations and protracted legal battles. A termination clause outlines the specific circumstances under which parties can end their legal relationship and discontinue fulfilling their contractual obligations. Without such provisions, parties may find themselves trapped in unfavorable arrangements or facing uncertain legal consequences when attempting to exit a contract. Under standard agreements, there are several common grounds for termination. These include mutual consent between the parties, material breach or failure to meet conditions, bankruptcy or insolvency of one party, or when a legal order prohibits the continuation of the agreement. Termination clauses generally fall into three main categories. First, termination for cause allows a party to end the contract when the other party fails to fulfill their obligations. For example, if a database migration company fails to complete the promised work, their customer could terminate for cause and potentially seek damages. Common grounds for cause-based termination include failure to meet key performance indicators, persistent late payments or deliveries, violations of confidentiality clauses, misrepresentation or fraud, and failure to maintain required licenses or permits. The second type is termination for convenience, which permits a party to exit the agreement even when no fault exists on either side. These clauses typically specify how to calculate compensation owed to the non-canceling party. Termination for convenience provisions are particularly common in construction and government procurement contracts, allowing owners to terminate a contractor's work at their discretion. Such clauses usually cover the actual costs of completed work, costs incurred by the contractor, any termination fee, and language preventing further claims against the owner. The commercial impact of these clauses can be significant, affecting revenue assurance, business continuity, and trust between parties. The third main type is fixed-term termination, where the contract naturally concludes after a specified time frame. Teacher contracts that end after the school year exemplify this approach. Fixed-term agreements may include automatic renewal provisions, unless one party provides notice of non-renewal. When drafting termination clauses, several best practices should be followed. The clause should clearly state whether termination can be mutual or unilateral. Including a right to cure provision gives the breaching party an opportunity to remedy issues before termination takes effect, typically within 10 to 30 days. Well-crafted termination clauses should clearly define triggering events, specify required notice periods, state any penalties or fees for early exit, outline obligations during the wind-down period, and remain consistent with other contract provisions. Beyond the legal necessity, termination clauses serve as strategic tools for risk mitigation. They empower parties to exit contracts under specific conditions without breaching the agreement. Without such provisions, termination options become limited to fundamental breach or frustration of contract, often leading to legal ambiguity and expensive disputes. In commercial settings, especially those involving long-term or high-value agreements, clear termination provisions help businesses avoid financial exposure, protect their reputation, and ensure compliance with evolving regulations. They also provide better negotiation leverage in scenarios involving mergers, acquisitions, or business scaling. Enforcing a termination clause requires following proper protocols. This includes providing written notice to the appropriate contact, citing the specific clause and reason for termination, documenting all communication and evidence, and managing post-termination obligations such as data return or transition services. Failure to follow these steps can result in wrongful termination claims or breach of contract liability. Vague termination clauses may lead to disputes or be deemed unenforceable, with courts often interpreting ambiguous language narrowly. While termination clauses aren't technically mandatory, Including them is highly recommended as they provide clear exit strategies and reduce legal risk. In high-risk sectors or complex deals, tailored termination clauses become even more critical for protecting business interests. Before invoking termination rights, businesses should carefully consider the commercial impact, potential reputational harm, and enforceability of their position. A thoughtfully constructed termination clause reduces uncertainty, defines expectations, and ultimately protects all parties involved in the contractual relationship.